My name is Morin, and I'm the principal attorney and founding member of Morin Legal. Today, we're talking about contracts. And when I actually thought about in what context could we communicate basic tenets about contracts, I realized we were still somewhat limited to really the nature of our practice, which is mostly transactional and involves transacting either some type of intellectual property right, either based in copyright law or trademark law, or some type of personal right. With that in mind, let's proceed into the top 10 aspects of a basic transactional contract. We're going to start with number 1, the key terms. Key terms to any contract include the identity of the parties to the contract, and that can be really important depending on how you want to be taxed for the income you receive in the contract and other things. The subject of the contract, of course, is important. The consideration to be paid in the contract, which can include compensation but doesn't have to. The term or the period during which the contract should apply, and the territory in which the contract applies. Keep in mind now that contracts are really guidelines to behavior, right? In which parties agree to a certain course of conduct of doing business. Now, the second most popular, number 2, in our list of top 10 aspects to a transactional contract are the right paragraph. So there's a provision usually discussing the rights to be transacted. And as I said earlier, the rights might either be based in intellectual property law, in some aspect of copyright law or trademark law, or trade secrets even, and or personal rights, including commercialization of the person's identity, including the name, the image, likeness, and so forth. So number 3, once we get past the rights being transacted in the agreement, typically we will see something related to confidentiality. And the trigger that lets you know that you are reading a confidentiality provision is that it usually has to define what is confidential information. So typically doing business with another party, you might get access to information that might not otherwise be publicly available, but be necessary for performing the agreement. And the parties agree that sharing such information will be done under certain conditions. And those are certainly outlined usually in some provision related to confidentiality. Number 4 on our list are reps, warranties, and indemnities. Reps and warranties are things like representations. Reps is short for representations, but essentially representations of fact, material representations that you make in order to enter into an agreement that other persons are depending upon. Warranties or promises, certain behavior performed to a certain level of care. And certainly indemnities are there in the event you break any of those representations or warranties, break any of those promises, misrepresent some aspect of the fact, and that entitles the person to be defended. Number 5 on our list are remedies. So what happens if somebody doesn't perform? And a notice and cure provision is extremely helpful for functional reasons, because it keeps you out from having to go to court right away to enforce an agreement. It just essentially means you're letting the person know they're not performing up to what they agreed to, and they have maybe 2 weeks to cure the conduct. And certainly that is one tool in the toolbox that is great to exercise. Maybe it was an innocent breach, accidental for mispayment, misfiring of a check or something, something innocent. But needless to say, is one step before having to go into the next bit, which is considering the termination, right? Number 6 on our list is termination. Always tell clients never get into an agreement you cannot get out of. So look for the termination conditions and what are the effects of termination. Do you have to give back documents? Are the materials you create frozen in the process? What type of agreement really determines what the effect of termination is. But it's always good to see that you have a paragraph related to termination or otherwise an exit from the contract. You don't want to get into something you cannot get out of. Number 7 on our list is alternative dispute resolution. This is an inexpensive and effective way of resolving your disputes. Again, if the person doesn't cure their conduct, you go into the next bit, which I like to keep it low cost and start with basic negotiation on the side of either party through the representatives. And then if that doesn't work out, going into mediation, and after that, arbitration. Number 8 on our list is the choice of law in the forum. This is important. if you are going to have to settle your problems under the contract, some contracts say, listen, we know that you're in Georgia, but the choice of law in this contract is going to be California or New York. And guess what? That's where the forum will be. And so you're going to be traveling to that date and staying in that city if for any reason you have to go into a mediation or an arbitration in California, for example. All right, number 9, boilerplate. Boilerplate is on every contract. It's a paragraph talking about how this is the entire agreement. There's no other agreements that apply. All of your intentions are reflected in this one single document. That's something we call a merger agreement. It also provides, if the parties want to amend or change their terms, a mechanism for them to do that. It provides if somebody waives their rights to enforcement or to something else, that they're not agreeing to a future waiver. It says, listen, if terms are illegal, or otherwise impossible to perform, we can sever them from the agreement and not destroy the contract. There's other sections in the boilerplate on headings and counterparts if you're signing 2 different originals in different areas. Now we have electronic signatures. So our number 10 is signatures, because you can electronically sign documents in the transactional space and be able to, with the exception solely of affidavits which need to be notarized, right? Again, still those must be done in front of a notary in person in writing. So, but otherwise, electronic signatures have served us well in the contract world for transactional agreements. And that concludes our very brief contracts masterclass numbers 1 through 10 of basic parts on any contract.